Welcome back to Civic Education Minds. I'm Teacher K. Today, we are going to look at the criminal case procedures. So basically, we want to look at the steps that are taken in a criminal case as it has been outlined in the Criminal Procedure Code, which is sometimes referred to just as the CPC. So the first step is arrest or apprehension. Now, what does arrest mean, or what does apprehension mean? This is when the accused is taken into custody with or without a warrant. That is arrest or apprehension. So what is the difference between arrest and apprehension? Arrest, this is when a person is taken into custody with a warrant that has been obtained from the courts of law, and the person has been accused of committing a non-cognizable offense. Apprehension, on the other hand, just simply means a person is taken into custody after they have committed a cognizable offense. We can define a cognizable offense as an offense that can easily be seen as a crime. With this offense, there is no warrant that is required for a person to be apprehended. Now, some examples that we can give of a cognizable offense are murder, rape, theft, kidnapping. Some of the examples that we can give for non-cognizable offenses are forgery, cheating, assault, maybe defamation. Now, when we compare the two, a cognizable offense is a heinous crime. It's a serious crime. While when we look at the non-cognizable offense, these are comparatively less heinous, meaning they are less serious. The second step is plea. Now, what is this plea? Now, this is when the charge against the accused has been read, and it is the first time they make their appearance in the courts of law. Now, the prosecutor, who are the ones that are accusing, will read the facts of the case, and a plea will be taken. Now, if the person who has been accused admits to the offense, they are going to make a plea of guilty. This means that they are saying, I am the one that committed that crime. At this point, the prosecutor will produce and read previous records of conviction if there are any. And there will be no trial that is going to take place in the court. Instead, the court is going to proceed to convict the accused. Then mitigation is going to follow, where the accused is going to ask the court for leniency, for mercy, and then after which sentence is going to be passed. If the accused denies the charge, they are going to make a plea of not guilty, saying, I am not guilty of the crime that I've been accused of. And once they have denied the charge, a date is going to be set for trial, which means that both parties now are going to appear in the courts of law to prove that there was a case to answer. The third step is trial. Coming from the plea, the person has denied that they did not commit the crime. So we are saying, now let's go to the courts of law so that we prove that indeed there was a crime that was committed, and it was committed by this individual who has been accused. Hence, what is the purpose of a trial? The purpose of a trial is to ascertain whether the person who has been accused is guilty or not guilty. The trial is going to have two parties, prosecution and the defense parts. Those are the two parties that are going to be involved. The prosecution, which is the party that is accusing, will build a case against the accused, and the witnesses will be called, which are known as the prosecution witnesses. These are going to give narrations of what happened, which are known as examination in chief. And each witness may be cross-examined by the accused and their legal representative, who are known as the defense, meaning the person who has been accused is also going to have his legal representatives, lawyers that are going to speak on his behalf. The prosecution will re-examine the witness to correct any damage that the defense may have done, if there is any damage that has been done, because the two sides are going back and forth about what happened, the facts of the case, and so on. From there, if the court establishes that the accused has a case to answer, this is known as prima facie in Latin, then the accused is put on her or his defense. That is the trial stage. Then we go to the fourth one, which is the final submissions. Now here, the prosecutor is then going to make summaries of their main points of the case and also urge the court to convict the accused, because that is the point for the prosecutor, is to make sure that the accused will spend time in prison. On the other hand, we have the defense, who are going to also address the courts and urge the court to find the accused innocent. These are the ones that are defending this person, so they are going to ask the courts of law to find this person innocent. After that, we're going to have judgment. Now, under judgment, the magistrate or the judge that is going to be in charge of this case will deliver judgment. This is the final ruling or the verdict. The person has been found guilty or the person has been found not guilty. They are going to give their verdict. In other countries, they use what they call a jury. For some countries, it's either a magistrate or a judge. Those are the ones that will make the final verdict. Once that has been done, records of the previous convictions, if this person has been convicted before, these records are going to be brought before the courts of law. So the prosecutor will read to the court any previous convictions, and the defendant will either accept or reject these records. Then from there, we go to the mitigation step. Now, under mitigation, we talked about this earlier. We said if the accused has been found guilty and convicted, they'll be required to provide reasons as to why they should be given a lenient sentence. As in, they'll ask the courts of law to have mercy in the sentence that they are going to be given. And the court is going to ask for a reason as why they should be given this lenient sentence. Then we have the eighth one, which is sentencing. Under sentencing, the magistrate or judge will then sentence the accused, and they will be guided by the three principles of sentencing. The first one is retribution. The second one is deterrent, and the last one is reformation or rehabilitation. I am going to look at sentencing in a separate video because there are a number of things that we also need to know about sentencing, as in looking at the types of sentences. But for now, these are the three principles that are going to guide sentencing: retribution, deterrent, reformation, or rehabilitation. So all in all, we have looked at the stages in a criminal justice process in the Zambian legal system. We have arrest, plea, trial, final submission, judgment, records of previous convictions, mitigation, sentencing, and the three principles under sentencing, which are retribution, deterrent, and reformation or rehabilitation. So these are the stages. Thank you for being with me. Please subscribe to the channel, comment, like, share. I will see you in the next video.